Good day, viewers. Please sit back, relax, and enjoy the news today. Please feel free to share what you think and feel. Please don't forget to like, share, comment, and subscribe.
Kate Benjamin mo Africa wa Mahila. My initials are BMWM. I know it's quite a long name, but nonetheless, I'm here representing the first applicant in this matter, Mr. Thabo Bester.
Thank you very much.
As the court is ready, under case number 2025-16001. I'm Mr. Mwela. I represent Ms. Magudumana, together with my learned colleague, Mr. Thabo.
Thank you very much, Mr. Mela.
I appear for Netflix together with Ms. Nandipa. In the Bester matter, I appear for Netflix together with Ms. Kate.
Thank you very much. Yes, thank you. You may assume I've read the papers in as far as I could, because they were all filed very late, but you're welcome to proceed.
As the court pleases. My lady, as you have brought an application before you, it has got two parts. Part A is the one that has agency, which seeks the interim, the interim interdict. And first of all, I would want to start by arguing the agency aspect of it. Nonetheless, we have agreed with the respondent counsel to say we'll proceed with the whole argument, and we'll also have the second applicant proceeding with his argument, and after we'll reply later on. So I will just start with the agency, then after that get into the merits of the matter as it is.
You're welcome.
As per the papers that we have already received, is that this matter is not urgent according to the respondent. But nonetheless, we are arguing that this matter is urgent simply because we are having a documentary that must be broadcasted or flighted tomorrow. And that fact that there will be a broadcast tomorrow on the 12th of September, it means that confirmation of an event or a date of saying on the 12th, Netflix will be broadcasting the documentary. It becomes an agent triggering event. When we have that as an agent triggering event, we cannot wait any longer to have this matter heard at any other time. And having said that, I will want to bring the court to the attention of a case of Luna Miebel, BPK. This case has decided has laid down the principle on Rule 12, subsection 6, whereby it stated that for agency to be, there are two things that need to happen. Number one is that the circumstances of the case justify the shortening of times and the non-conformity from the rule. Number two is that if a matter is not heard urgently, that the applicant will not be afforded substantial redress at a later stage. The first thing that I want to talk about is that we requested the shortening of the time simply because should we wait any longer for this documentary to be flighted or broadcasted, we then have a situation of saying the impact that it would have made, it will not be reversed or anyhow amended. That's why we requested that this matter be heard on urgent basis. Then number two, we are dealing with the issue of substantial redress at a later stage. On our part A, we are arguing to say, should this Netflix documentary be broadcasted, my lady, how will Mr. Bester be afforded any substantial redress when this very documentary, seemingly it has got impact on his trial, which is pending?
Well, the magical word you used is seemingly.
It will have. Remember, I'm saying seemingly because we don't have the full, we don't know what is contained fully in the whole documentary. We are talking about the trail of almost 30 seconds or so that has been exposed to us. So according to the trail that has been exposed to us, there is so much that seemed to have an impact on him. even on that shortest 30 seconds, we have a lot that we can say. These are some of the words that are said that will have impact on the trial of Mr. Thabo Bester. And I will come to the merits and explain some of the things that I'm speaking about from the trailer. So now, on the issue of agency, we cannot wait for any, we do not have any substantial redress at a later stage. The only substantial redress that we can have now is to say, we can only have it now to say, let this documentary be interdicted not to be flighted tomorrow, not to be broadcasted tomorrow. Why? Because the moment it's broadcasted, whatever that is in there, it is most definitely going to affect our client's trial, which is pending at the moment. And also, I have one interesting case of Mogalakwena Local Municipality versus Provincial Executive Council, where Judge Tuchen stated in paragraph 64 that it seems to me that when agency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be agent. Once such prejudice is established, other factors come into consideration. I want to emphasize the aspect of prejudice. To say, here we are having an agent matter because there is a prejudice that the applicant, Mr. Thabo Bester, will suffer. What prejudice are we talking about? Number one, we are referring to the right to a fair trial, Section 35(3) of the Constitution of the Republic of South Africa, Act 108 of 1996. Now, we are also referring to the right to human dignity, which is in Section 10 of the very Constitution I mentioned. And we are also referring to Section 35(3), which is the right to be presumed innocent until proven guilty. Now, when you look at the trailer of the documentary that Netflix want to broadcast, there is so much that leaves, that is left undesired for our client, Mr. Thabo Bester. Why? Because there is somewhere there where it is stated, one of the speakers in the documentary state that Mr. Bester faked his death and escaped from prison, not allegedly. He speaks it as though it's the gospel truth, as though it's absolute, he has got the factual proof to say indeed he faked his death and escaped. And these are the allegations before court. It has never been established, he has never been found guilty at any point. We also have got a challenge with the trailer itself, because we have in the trailer, number one of the co-accused, which is the father of the second applicant, Nandipha Magudumana. What challenge are we having there? There is a phrase that the father of Nandipha Magudumana says. He says, I cannot imagine my daughter doing such a thing. The question is, what a thing?
And how does that reflect on Mr. Bester?
We are coming to that. We are coming to that. Then we have an issue of saying, what is such a thing? Definitely when we speak of such a thing, which the trailer has already suggested, where one of the speakers says, we don't know whether Dr. Magudumana is an accomplice or a victim. Now, accomplice to what? To Mr. Bester, whom already the trailer has rendered him to have faked his death and escaped from the prison, which is not allegedly, it is stated like that. And I would also want to direct the court to the answering, I think the answering affidavit of the respondent, Netflix. There are some interesting things that are being said there that that the court really need to look at them in order for us to be able to find a way forward. When you read the answering affidavit, it's kind of unclear what are they saying about this this documentary. Somewhere there on, let me quickly look at that. Somewhere there on their papers, They say Mr. Best, this documentary is not about Mr. Best, it's not about Mr. Thabo Bester. They state it, but somewhere there, they simply state it clear that it's about Mr. Bester. And then still, that is what the court needs to look into. In paragraph 28, of the answering affidavit, it says, at paragraph 46 of the funding, Mr. Bester alleges that Netflix is exploiting his life story for financial gain without consent, which seems to be a repetition of his personality rights argument. As indicated above, this rejected. There is no exploitation of Mr. Bester's life story. The documentary focuses on the prison and criminal justice system, as well as broader societal issues about social media, gender-based violence, public safety. This is not Mr. Bester's life story. It is proven this will be a private law claim and remedial through damages. So now they say the documentary is not Mr. Bester's life story on paragraph 28. And I want the court to also look at paragraph 9 of the answering affidavit again. It says on paragraph 9, the Beauty and Bester, which is the subject of this application, is similarly a true crime documentary. True crime documentary. It profiles one of the most notorious events in South Africa, recent criminal justice history, the escape from prison of Mr. Bester. The escape from prison of Mr. Bester, who is convicted murderer and rapist. His relationship with famous and glamorous medical doctor, Dr. Nandipha Magudumana. It is this documentary which Mr. Bester does not want the Netflix viewers to see. The documentary was produced by a company trading, this part is not important for my argument. The most important part is that they said this is not about the life story of Mr. Bester. Now here they come on paragraph 9, that this is about the escape from prison of Mr. Bester. Escape from prison. The problem is this. We said we are arguing on section 35, subsection 3 of the Constitution, whereby everybody has got a right to be proven innocent. Everybody has a right to be declared innocent until proven guilty. Now here we have a situation of say the Netflix, it is putting it as a confirmation, as if there is a judgment that Mr. Bester has escaped from prison. And there has never been any proof that says he has escaped from prison. He has never been convicted on that. And that is what the court needs to look into when it look into this this documentary. And also on that, speaking about the documentary, there is a very interesting aspect that turns this documentary not into a social commentary. It turns it into some sort of a kangaroo court, or a quasi-court, or a moot court, whatever kind of a court we can call it. Because somewhere there is one of the most respected legal person in this country, Judge Cameron. Judge Cameron...
Are you saying Judge Cameron is the head of a kangaroo court?
I'm not saying he's the head of the kangaroo court. I will not even dare to say that he's the most senior. I have to give him so much respect. I'm saying this documentary becomes some kind of... I have never impliedly said that, and I will never say that. And I'm not even creating that impression to the court.
Well,
what I'm saying to the court is...
Yes?
Permit me to answer, and I will finish my statement. What I'm saying to the court is, we are having Judge Cameron featured in the documentary. The first thing that he says, which is just a line in opening, he says, this is the most improbable thing that I've ever seen as a judge and in my life. Now, Judge Cameron is speaking as a judge and also in his personal life. He is not just there as a commentator. He is there as a judge, and he acknowledges his position. He says, as a judge. And I am saying, or rather we are saying in our application, such makes this whole documentary to take a different turn. Because the moment a former judge who has done so much work, we read so much of his precedents. I have so much respect of Judge Cameron. And I'm saying, him speaking there, talking about this as one of the most shocking stories of his life, it then creates a certain element in this documentary to say, it seems like Mr. Thabo Bester, who is fully a center of this documentary, is already found guilty in a documentary. And why am I saying this documentary is still about Mr. Bester? Because they say the beauty and the Bester. Who is Bester? Is Thabo Bester. Now, we know the phrase Beauty and the Beast from one of the old movies. Now, the Beast no longer exists. Who exists? The Beast has been replaced by Bester. So it means that in the nearer future, we are likely to have a situation whereby when kids are asked, what do you know? They won't say the Beauty and the Beast as we knew in the literature of English ourselves, who grew up during that time. They will say the Beauty and the Bester, meaning that the beast has been replaced by a certain individual. Now we have a beast in person and personified into the person of Thabo Bester. So then this documentary, from its naming angle and perspective, it has already brought what we call a serious defamation to the person of Thabo Bester. And we cannot sit and keep quiet when Thabo Bester, who is my client and the applicant in this matter, is being termed or rather narrated as the beast. Because that's what the documentary suggests. Proceeding on engaging the answering affidavit, my lady. I have there is something here that is very interesting. On paragraph 27, on paragraph 27 of the answering affidavit of the respondent.
Can you refer me to the page, please?
Let me ask my colleague here for a page. Thank you. My colleague just assisted me. He says it's 137. Oh, 00005-137. Apologies for the delay, my lady.
Thank you.
I am reading from the hard copies. I'm still functioning like an old lawyer, even though I'm young.
Yes, I'm there.
As I proceed on paragraph 27. At paragraph 28 and 29 of the founding affidavit, Mr. Bester alleges unlawful exploitation of his personality rights. There is no exploitation of Mr. Bester's personality rights. A documentary about an alleged escape from one of the most secure prisons in South Africa is clearly in the public interest. Moreover, this documentary deals with broader issues of global significance, including social media, gender-based violence, public safety. Netflix is entitled to commission such documentary. If there is a course of action based on this, it can be addressed later in civil action. For now, the public is entitled to make up its mind about the prison system is alleged to have allowed a convicted man to escape from a maximum security prison. Now, reading paragraph 27, it creates an impression of saying, this documentary will simply come and say, we have done our research, we have the fact, we have found the truth, Mr. Bester has escaped. But there is no court that has declared, that has made a judgment on that. And if they say the public is entitled to make up its mind about how prison system is alleged to have allowed a convicted man to escape from a maximum prison, a convicted man has escaped from a maximum prison, they are already creating an impression of saying he must be found guilty. And that's where now we are talking about a fair trial right being eroded or violated. And also, my lady, I want you to also look at something that is very interesting here on the very same answering affidavit. On the very same answering affidavit. On paragraph 40 of the answering affidavit, it says, I hope the page will not be a problem this time. on paragraph 40 of the answering affidavit, it says, Mr. Bester's allegation about consent, participation and approval rights are thus both factual, inaccurate and legally irrelevant to the relief sought. There is simply no basis upon which a notorious public figure such as Mr. Bester can seek censor to censor speech about him simply because he has not given consent. If this were the law, no speech about public official or public figure will be permissible absent absent their consent. Now, I want to direct the court specifically to this phrase that says there is no simply basis upon which a notorious public figure such as Mr. Bester can seek to censor speech about simply because he has not given consent. Now, because there is Mr. Bester who is purported notorious, and this has to be questioned, how do we conclude that somebody is notorious? Is there a measure that Netflix uses to declare somebody notorious? Do we have 1 to 10 to say Mr. Bester is notorious? When you cross the bar of 8 allegations, so you say that's where you are notorious. Or how did they conclude that he's notorious? And having said that, they still come to say there is no way he should consent. It means that now the right to dignity of Mr. Bester is in question. He has no rights anymore. He can be spoken about as if he's just a piece of meat that has no feelings, emotions, or mind. Then that's where the court needs to look into this documentary as a violation and erosion of human rights. Because if Mr. Bester is notorious and we can talk about him anyhow and have people speaking there and declaring him guilty as if they've got all the facts right and the court has backed their claims, then we are having a challenge in South Africa when it comes to protecting human rights. And also, I want to bring a very interesting point in this, to say, the way this documentary has been sensationalized and the vibrations of it, including the emotions created, there is somewhere one speaker on that documentary says, "Are you dangerous?" And they edited it, putting Mr. Best on the other side, saying, yeah, as if he's answering that question that he is dangerous. Now, that is manipulation. That is artistic manipulation. Very wicked craftiness of the editors of this documentary. Because they are sitting there, putting stories as if he is confirming that indeed he is a dangerous man.
Where is this in your papers?
It's there in our papers. In my founding papers is there. It's there in my papers. Everything I'm saying is in my papers. I will not waste court time and speak from my mind.
I'm asking you a question, you can just answer it.
It's in our replying affidavit. It's in our replying affidavit.
Yes, because it definitely wasn't in your founding, so it's something new.
Yes, it's. My lady, I didn't get that one. Can you please repeat that?
I said it wasn't in your founding affidavit, so it's something new in your replying affidavit.
Yes.
Where is it in your replying affidavit?
Actually, in our funding affidavit, we do explain about the manipulative editing that this documentary has. And on our replying, we were expounding on that. Actually, our replying, we were adding more meat to what already is being raised in the answering affidavit.
So where's this about Mr. Bester, and then as though he answers yes, he's dangerous?
I'm trying to get the paragraph of, the actual paragraph where this is being actually said. My lady, on paragraph 31.
Are we in the founding or replying?
Is on my replying.
Okay.
Is on my replying on paragraph 31. On paragraph 31. Excuse me, my lady. It reads thus: as argued in my founding affidavit and elsewhere in this affidavit, Netflix has employed crafty and manipulative editing practices in the publication of this documentary, which can also be seen in the trailer, where one of the commentators is shown to be asking the question, will you say you are a danger to society? And a video clip of myself is then superimposed after stating something along the lines of, yes, I will say so, or yes, I believe so.
Thank you.
So we have that in our papers. So now this also shows that this documentary simply tries to drive a certain narrative about Mr. Thabo Bester. And now if we have this kind of a documentary being flighted, whereas on the 19th of September, next week, Friday, he will be appearing in court, what is the impression that is being created there? And also, these are type of documentaries that make the public to believe that somebody is guilty. When they are not found guilty, then the judiciary will be looked at with wrong eyes or will have a bad reputation, simply because there were some prominent people, celebrities, who were speaking, social commentators, that he is guilty. And this is so emotionally created that it becomes one of the greatest assets of manipulation that you look into this documentary. I saw one of the celebrities, well-known figure, crying. I wonder, why is she crying? What does she know? Was she there? So these are some of the questions that we really look into. And also, one of the impressions that Netflix or the respondent is creating is to say they are listing a number of articles that have been written about Mr. Thabo Bester. To say it has been written about his rape cases, his Facebook, whatever. They bring many articles that they Googled and they printed them and brought them to court. Now, my question is one, is that because there has been so much published unfounded without having the actual proof of that, should we allow the further publication on that? Is that how things must be? Because some articles have been written in some newspapers, some video clips have been made on social media. Must we allow also Netflix to do the same? And Netflix has already described itself as one of the giant media houses that says it has got 300 million, how many? 300 million subscribers or viewers. Now, if Netflix published this tomorrow, this documentary tomorrow, just for 1 hour, with their 6-point-something million followers in South Africa, it means that in a space of 1 hour, after this radical marketing that they have undertook with this trailer and this documentary through the trailer, it means that we are going to have many people seeing this, and after to see this, a public opinion and the public court would have decided otherwise about Mr. Thabo Bester. Then when that has happened, the question I'm having is this: are we still going to have are we still going to have a fair trial in that regard?
Sorry, are you saying that a documentary will influence a court, a judge?
I'm saying,
because I find that quite preposterous. Because let's just take it to the end. A judge can only make a finding on the evidence that's before him, and it can definitely not be on a documentary.
I am saying a right. What I'm saying, which is in my papers, I'm saying a right to be presumed innocent until proven guilty, which is section 35, subsection 3 of the Constitution, needs to be protected. This documentary, I'm answering your question. Allow me a space to elaborate my answer. I will answer you fully, my lady. I am saying section 35 subsection 3 of the Constitution, a right to be presumed innocent until proven guilty, has to be protected, including even with a notorious person as labeled by the respondent, like Thabo Bester. Why? Because should that be, when he is found guilty, we do not know what influence will that be. We don't know the amount of influence will that documentary be having in that proceeding. And we are saying such documentaries carry a weight into the public court, carry a weight into the public opinion and interest of the people. And also, my lady, hear my argument within the context of everything that I've been saying for past 30 minutes or so. I have already said, in this documentary, we have the accused, one of the co-accused, who is speaking, the father of Nandipha Magudumana. I'm repeating that. And she says, I could not imagine my daughter doing such a thing. It's left there so that people can go and watch the documentary to hear what such a thing will my daughter be doing. And now we also have a judge, Justice Cameron, speaking in that documentary, saying, as a judge, I have never seen such a thing. What a thing is that? Definitely we are talking about Thabo Bester's alleged escape, which already the answering affidavit have stated that this documentary is about that. Now, my argument says, when such documentary are flighted or broadcasted, we then are standing in one corner of the truth, because he is also not given a right of reply. But that is not part of this argument. It's part B of the argument. I'm just saying it in passing because it has to balance my argument. Part B has to balance my argument in part A. So, the court finding him guilty or not finding him guilty, the moment he goes on the street and is not found guilty, because I believe that he's hiring lawyers like us so that he should not be found guilty. He will not be found guilty, I suppose. Then the state has failed to prove his case beyond reasonable doubt. Now, already the documentary has stated some kind of their truth or some kind of their baseless facts to say he has escaped. Now, it means the judiciary of South Africa allows somebody to walk free who has been found guilty by the public opinion. I am addressing the public opinion, and I'm speaking about the fair trial here. And I'm speaking about the right to be presumed innocent until proven guilty. And that cannot be left unattended. Now, having argued all this, my lady, the question is, why are you in court and sweating so much, Advocate Maila? The reason we are in court is because we are asking that this documentary should be interdicted. On which basis do you want this documentary to be interdicted? There is a case, as I'm closing, there is a case of Setlogelo versus Setlogelo, which is there on my practice notes. The case has laid down very important requirements for an interim interdict. Number one, it stated that a prima facie right, though open, what is required for an interim interdict to be granted by the court? Number one, a prima facie right, though open to some doubt. That's number one. Number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. Number two, the absence of an adequate alternative remedy. The absence of an adequate alternative remedy. Number four, the balance of convenience favor the grant of the relief. Number five, the balance of convenience favor the grant of relief. Then the last one. Oh, this is me reasoning. This is the fifth one will be the balance of convenience favors the grant of relief. Now, my lady, when you look, when you look at our founding affidavit, the applicant has covered all the requirements set out in Setlogelo case. Number one, prima facie right, you have already stated. that there is a right to fair trial, which is section 35 of the Constitution, a right to be presumed innocent until proven guilty, which is section 35(3) of the Constitution, and also a right to dignity, which is section 10, a right to equality, which is section 9, and also number 2, a well-grounded apprehension of irreparable harm if the interim relief is not granted. There is a phrase we use there to say once the bell is rung and the documentary is flighted, what then will be of Mr. Bester? And people have seen the story, have heard whatever that has been heard. What more will be? Obviously, there will be irreparable harm. After the documentary has played for 1 hour or 2 hours, since they said it's 3 parts, after the first part, they are done with Mr. Bester. He's already guilty by the format of the trailer. Number 3, the absence of adequate alternative remedy. If this documentary of Netflix is not interdicted, my lady, what more will remedy be for him after it has been flighted or broadcasted to 300 million followers of Netflix in 160 countries as they boast? Definitely, Mr. Bester, in every corner of this world or planet Earth, he will be known as a man who faked his death and escaped, because we saw it in the trailer. It's there. And number 4, the balance of convenience favors the grant of the relief. I mean, when you read what the respondent says in their papers, they say the reason this has to be played or flighted is because they cannot keep their their followers or subscribers in suspense, meaning their subscribers are more important than the human rights of Mr. Bester. Their intellectual or emotional tickling and their feelings must be created at the expense of Mr. Bester's rights. Now we also have we also have the convenience that the convenience favor the grant of the relief. What more will be convenient for the court except to order an interim an interim interdict? I do not see any possible way except this. And the court must note in our papers, we do not say this must not be unpublished. We say let the trial end, and they will publish it, whether he's found guilty or not. They will even have more, because it will have even the trial in it. It will even have this part. So they will have a bigger meat to give to their 300 million subscribers. So now, my lady, I also want to conclude on this case that deals with the specific requirement for prohibition of media broadcast. It's coming from the case of Media Television versus Director of Public Prosecution, which the respondent has labored very hard on it. Here, the Supreme Court of Appeal was asked to prohibit the broadcast of a documentary on the grounds that it might prejudice a pending criminal trial. The Honorable Judge Nugent held that the publication may be prohibited where a prejudice it might cause, 1, a demonstrable and substantial harm. Number 2, where there is a risk that the prejudice will occur. Number 3, that the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, looking into what the Media Television case has brought, we are sitting now, my lady, on an argument of saying, does Mr. Bester has a case that can be decided in line of Media Television case? Indeed, you look at number 1, that a prejudice is demonstrable and substantial. My lady, if one of the accused, father and also the co-accused, and the father of one of the accused says, I could not imagine my daughter doing such a thing. What a thing. I'm wondering, what a thing is that? Definitely it's not talking about her daughter graduating to be a medical doctor. Most definitely it's talking about the assisting or doing whatever in this alleged escape of Mr. Bester. Definitely it's about that. And number 2, we are talking about, the case says there is a real risk that prejudice might occur, will occur. Once this documentary is flighted, prejudice will occur. What prejudice is that? We can mention close to 20, but for now, I will say to save time, let's mention 2 or 3. Number one, we have 300 million subscribers who will be listening to people declaring a man whom the court has not declared guilty to be guilty, who are sure of what they do not know. That contradiction there, they are sure of what they do not know, as if they were there when they saw him escape from a prison. We have that problem now. And we cannot allow that to be flighted, because there is a trial coming. Let the trial decide. After the trial to decide, that will happen. And my lady, this is not the first documentary, by the way. We have documentary of many celebrities with their trials, including your Oscar Pistorius, including your Mudimulle, Monster, all of this documentary after the trial. Why is this one supposed to come up now? Now, number 3, the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, there is an argument of saying we are affecting the freedom of expression of Netflix. But the truth of the matter is that we are not. Because this documentary is their investment, they have made it with their money. They can still archive it and do more parts, play it later. It will still be there in their archives. That is their intellectual property right, or their right to creative work. So we are not doing this application to curtail the free flow of information. Perhaps at the time when they do this, Mr. Bester will be granted a right to reply. So my lady, having said that, this brings me to the conclusion of my argument to say, if there is one thing that I will argue the court should do, is to simply grant an interim interdict of this documentary. Allow the court to make a decision on Mr. Bester's case, looking into the constitutional right of Mr. Bester. Number 1, a right to be presumed innocent until proven guilty. Number 2, a right to a fair trial. Number 3, a right to dignity. Number 4, a right to equality and protection of the law equally. Having said that, I thank you, my lady.
Thank you very much. Are we going to let you first answer, counsel?
Yes, I'm happy to answer, my lady.
Or do you want to first talk? Okay. You have got a microphone. Yeah, I was just worried.
My lady, we are in your hands, but I'm happy to just run it now. And then.
I think perhaps we let both of them argue.
Yes.
I think it's going to be easier.
Yes,
Are you
as
ready
you
to
please.
proceed, counsel?
Please, my lady. I'll just seek indulgence to set up this.
Yes, certainly.
My lady, going after Mr. Bester's case, it's not an admission that these cases are similar.
No, that's why we're doing them separately.
Yes, yes, but I'm putting them up front, just obviously for the purpose of convenience. And that is our point of departure. These two cases are markedly different, and I will explain that particular aspect. But just to set the tone and not to accede to the defense by Netflix, I will read a paragraph from the Constitutional Court from Justice Krichler. It is at paragraph 23 of the applicant's head, Ms. Magudumana, page 007-20. 12. This is just to set the tone and to privilege this court with the necessary vocab that we are going to binge on and move with it to demonstrate the strength, if indeed this case is decided on Section 35 of the Constitution, ultimately demonstrating the weakness of the respondent's defense, this relying on Section 16 of the Constitution. In other words, they say this case, it's a contest or balancing of Section 35 and 16. We differ from that aspect, but I'm just reading this aspect to set the tone. In that, if we find ourselves there, we are covered by what I'm reading here. And this is what it says in that Sanderson versus Attorney General citation is there on the footnote. So we quoted paragraph 22.
Sorry, where's counsel gone? Oh, there you are.
Yes,
I can't see you.
I'm here, my desk. I'm here, my
Because
desk.
I want you to listen.
No,
Yeah.
I'm listening.
Okay,
As
yeah.
the court, please, Malek, this is what it reads. It's a lengthy paragraph, but you know, just to set the tone, I think that I'm going to read it verbatim. Others, I will assume that your ladyship, as it has been confirmed that these papers have been read. I will suggest in a moment why the fair trial protection of the accused extends to non-trial related prejudice. But my point here is simply that a narrow textual approach of Section 25(3) is likely to miss important features of this provision. That's a previous provision in the interim, which is then now Section 35. The central reason for my view, however, goes to the nature of the criminal justice system itself. There's a mention of a fair trial and the nature of the criminal justice. If we find ourselves in the debate of Section 35 versus Section 16, the double weapon that the applicant, Ms. Magudumana, has is the fair trial right, Section 35, and the administration of the criminal justice system. The harm is on all the citizens that deserve to have public faith in the criminal justice. Then it continues. If in principle the system aims to punish only those persons whose guilt has not been established in a fair trial, prior to a finding on liability as part of the fair procedure itself, the accused is presumed innocent. He or she is also tried publicly so that the trial can be seen to satisfy substantive requirements of a fair trial. The profound difficulty with which we are confronted in this case is that an accused person, despite being presumptively innocent, is subject to various forms of prejudice and penalty merely by virtue of being an accused. These forms of prejudice are unavoidable and unintended by the system. As a practical matter, the impact of a public process on the accused may well be to jeopardize or impair the benefits of the presumption of innocence. While the presumption of innocence will continue to operate in the context of the process itself, as a criminal process, it has little force in the broader social context. Trial by public. Indeed, many may pay no more than lip service to the presumption of innocence. Doubt will have been sown as to the accused's integrity, conduct in the eyes of family, friends, and colleagues. The repercussions and the disruption will vary in intensity from case to case. In this one, it's grave. But they inevitably arise and are part of the harsh reality of the criminal justice system.
But
You can-
isn't he saying that's part and parcel of it?
Yeah, my lady, when someone is setting a tone, must be allowed to do so. I will then elaborate. I'm setting a tone, and what Justice Clark is accepting that some of the things are part of the system, but we can't shy away from the fact that prejudices are highlighted, and trial does not only happen within the court, and prejudice does not only happen within the process itself. Then we say that, and that's a close quote of that particular case. So that means when I get to the aspect of Section 35, with what I've said, then the meat will be fleshed out. So now, dealing with what brought us to this court today, it's an interim application to interdict what is about to be paraded tomorrow, 12 September 2025, by Netflix, working together with Storyscope, pending the determination in Part B. In Part B, we say contemplated proceedings could either be action or application. It will depend on the assessment fully of the facts, whether there won't be any serious dispute of fact when that application is then prosecuted. And the prayers, what is contemplated there is that the respondents, all of them, the respondents, Storyscope, Netflix, contrary to what they do belatedly, they rely on the contractual terms of what is called a licensing agreement to tell the applicant, Ms. Magudumana, that if for any reason you have a right to breathe in terms of the Constitution, that licensing agreement does not allow you to do that, and it also blocks you from invoking that right in court, except if you want to claim for damages. So that particular contract is again public policy, and it will be determined fully in Part B. But this is a problematic aspect. She can't even, we are at the mercy of that contract. To even invoke Section 12, we are at the mercy of that particular contract, because the engagement, as I will demonstrate from the letter, when a demand is made first to the first respondent, that is Storyscope, ultimately to the second respondent, Netflix, the theme was the same. You have signed a contract. In terms of the contract, you can't even approach the court to assert any form of relief except the claim for damages. So she is at the mercy of Netflix. And how do they justify that mercy? They will tell you, you've signed a contract. Then, with that said, this is how you then need to categorize this matter and separate it from the first matter that was argued, which was squarely a contest between Section 35 and 16. This one is what we said under the overview rubric. It's peculiar and unique, and that uniqueness has not been appreciated by the respondent. So let me now deal with the aspect of agency. The biggest challenge on agency in respect to Ms. Magudumana, or the applicant in the second case, is an impression that she has created the agency, self-created agency. But there's a timeline accounting for each and every process that was followed before coming to court. Then I'll just take this court through the timeline quickly. But the timeline itself is started paragraph 71 of the founding affidavit, page 001-31. That is where the timeline starts, and then it takes you through until we find ourselves in this court. On the 20th of August 2025, it marks the first event that brought us before this court. That is page 001-117 This is the letter of demand by the applicant's attorney, directed to the first respondent, Story Scope, bringing to the attention of the particular prejudice that might ensue. So in other words, on the 19th, Mr. Machini, who's also representing Ms. Magudumana in the criminal trial, came to know about these sound bites. I won't repeat them. My learned colleague dealt with the sound bites and the content, so I won't repeat. He heard for the first time about the sound bite, and it resulted in this letter of demand being sent to the first respondent. My lady, I will presume that what has been pleaded in the founding papers obviously incorporates everything that is there, but it's simply a letter of demand, desist. Do not publish this without giving our client an opportunity to comment, view, and have an input. Not in terms of some natural right, in terms of what is common cause. There is a commercial agreement between Ms. Nandipha Magudumana and Storyscope. So it's quite different from that other particular one. It's not an issue of natural right coming from the air. It's a contractual right that she was also trying to invoke. Then the response from the first respondent, my lady, you will find that at page 001-122. And specifically, I want to direct your ladyship to paragraph 3 of that particular letter, if your ladyship is already there. That is the response from the first respondent. Paragraph 3, it says that, in particular, we will not be addressing any matters that pertain to Dr. Nandipha Magudumana, as Mr. Mgudwa and Mr. Mutlong, who has signed a release on behalf of Dr. Magudumana in terms of the power of attorney, are aware there are existing contractual obligations that apply to Dr. Magudumana. Then in paragraph 4, they say, I must candidly say that the extent to which the information has already been shared with yourself, the legal representative of Mr. Bester, obviously they were thinking that if you were once appointed, you are permanently appointed, in a manner that potentially violates those contractual terms, is a matter of grave concern to us. We reserve our rights in regard. So they say that I urge Mr. Mgudwa and Mr. Mutlong to consider the relevant clauses before further discussion. Is the clause of that agreement that says that she's not even allowed to see the doors of this court. Her section 34 right, she can't exercise. She only exercises at the mercy of the respondent only to claim for damages. Then Netflix, at on 26 August 2025, page 001-125. I said Netflix. This is the letter by the applicant. I want to direct the court to paragraph 9.2 therein.
I'm there.
Having seen the response from the first respondent in the letter that I've just read before, now it was clear that there might be some impasse between the first and the second, but the publishing is going to be done by Netflix. The first respondent is the production company. They have an arrangement. The applicant's attorney requested that they be provided with the information of Netflix so that they can then engage with Netflix, because ultimately it's Netflix that is going to publish this particular aspect. Then there was no response to that. And at paragraph 73 of the founding affidavit, which is then found at 001-32, the applicant asserts that, or the attorney visited Dr. Magudumana in prison for consultation to inform her about what's happening. Remember, she doesn't enjoy the same right that we enjoy. You have to set up a consultation to go to prison, to even give a report. So it's not for the applicant attorney to decide that now we are going to court. After everything that has been discussed, you must still report to the client and obtain necessary mandate. This is the meeting to obtain further mandate in light of what was about to happen. Then, at paragraph 77 of the founding affidavit, it is then recorded that an instruction was given that you can still engage, because Netflix has not been engaged. You can still engage. There is a possibility of this matter not reaching this court. Then you then have a letter on the 28th of August 2025. That is the meeting wherein this letter now is addressed to Netflix, substantially repeating what has been discussed with Storyscope and asking a roundtable meeting so that parties can find common ground. Netflix then responded only on the 31st of August 2025 to the letter of demand. And obviously they reiterate that she can't come to court because of the contractual clause, and particularly at paragraph 6 of that letter, which is found at page 001-136. That is the page number. Paragraph 6 of Netflix response says that Dr. Magudumana has also concluded an archive licensing agreement with our client, in terms of which she agreed commercial terms with our client for the use of her personal archives in the production of the documentary, and that she has waived the right to interdict. She has waived this right that we're trying to do. The right that she has in terms of Section 34 is simply access to court. She has waived it. And the court must endorse that. Because what? Netflix empowers artists in the country, invests a lot in the country, therefore they must be excused from the constitutional supremacy, must move to a capital supremacy. And then she has waived the right to interdict documentary. Obviously, the terms of the agreement are confidential, but the point is made. So, my lady, there's no escape that this matter is markedly different from what you've had in the first application. This is their own terms. You can forget about, obviously, what is then being attempted now in this court to confine it to that comparison. Then, just to move fast now, because we're on the 31st, I'll just summarize what then happened from the 1st to the 5th, in order not to derail this court. From the 1st to the 5th, there was engagement between Netflix and Dr. Magudumana. And particularly, in respect to the roundtable request, Netflix said, we've played open cards, we've placed our version fully, we've told you the limitation of your case, but you are not saying anything. But at the same time, you are requesting a roundtable meeting. Then Dr. Magudumana then paused for a moment that, wait, let's place our version, because it seems like the reservation of roundtable meeting is based on the fact that the other party is playing open cards, the other party is not. Then she then placed that version, that this is my version, on the 4th of September, and gave Netflix an opportunity to respond, failure of which she will approach the court. She gave them an ultimatum until the 5th of September, 2025. Then, on the morning of the 5th of September, Netflix did not just ignore that request, they said, please grant us an indulgence, we want to take further instruction. So they did not say, we have reached the loggerheads. They wanted to consider that particular aspect, and she could not have rushed to court when they said that we are taking instructions. Only after 3 hours did they say that now we have reached the deadlock. We are no longer engaging further. And that's when now the process of then approaching this court commenced. And they got the unsigned papers on the 7th, less than 2 days, on the 7th of September, unsigned. And then they got the signed one on the 8th. So they knew about the case from the 7th. On the 8th, it's simply the signed papers. And that's how, because of the exigency of the matter, it requires that so that you give your opponent sufficient time. But in any event, even on when a deadlock was reached, they were forewarned about what is going to be sought in court. A draft notice of motion was sent, and then a draft overview that, so that you can have a sense of what is going to be brought, so that you are not caught by surprise when you receive the papers, because that is the requirement. When you are prosecuting an extreme urgent matter, you keep your opponent abreast. In fact, they even say that we don't appreciate that you are sending us unsigned papers. So they are simply saying that don't even comply with the requirements that you should if you are prosecuting urgently. But they also want to use it, that now you don't even engage. You sit and then you come to court. So I've accounted to the aspect of self-created agency, and I would submit, my lady, that the applicant in that respect have met what is required. Give a reasonable account of what happened, not give the perfect account. This is perfect, but it doesn't say give perfect. Reasonable account is there in ISROP, is there in Mogalakwena. And the requirement is this. Once you are faced with an urgent matter, you have two things that you have to do. Investigate, try to resolve. I've dealt with the issue of trying to resolve. Investigate, consult with the client, seek more information. In fact, in one of the first letters, the respondent had said that it seems like you are not well vested with this information. You need to source more information, and then she did that. So I closed that aspect of self-created agency. And it also dealt with the issue of whether she will be afforded substantial redress in due course. When is this due course going to happen? Because even if she had elected that the due course is the normal course, wherein you follow the normal Rule 6, 10 days, 15 days, heads of argument, practice note, you get a date from the registrar. Here you are the registrar. But in terms of that problematic contractual clause, there's no due course for Dr. Magudumana. It doesn't exist. It can only exist if this court intervenes on an urgent basis. That due course will never ever exist. She will not enjoy. Unlike in the Thabo Bester matter, there's no any bar can invoke Section 35. Dr. Magudumana can't. She's at the pocket of Netflix. Netflix decide what right does she have in terms of the Constitution. It says that it's a claim for damages. She's not, if that is endorsed, it goes to the issue of unequal treatment. There's one person in this country that is not allowed to exercise any right in the Constitution, subject to approval of Netflix. That is Dr. Magudumana. Can't be argued that that's unfair treatment if this court is going to endorse that. So she must live with that, with the unknown due course, and with the consequential harm, which is then, remember, if you can approach the court and this documentary is allowed to be published, we then say that these are the further harm. The first harm is that your Section 34 is blocked. But the consequence of that is that Section 35, there's a reasonable apprehension based on those sound bites that my learned colleague dealt extensively, that it will be violated. That's why you say that there's a reasonable apprehension. You don't have to wait for the harm to happen.